So thank you for joining me this afternoon. I'm Michele, as I said, and I'm a financial, I would say I'm an estate simplifier. So I hold people's hands through one of the toughest times of their lives, when someone close to them has passed and they have all their personal items, their stuff that's left behind there, and they have the paperwork to do, the tax stuff, the legal matters, and I have to address all this stuff. So I'm a professional executor, trustee, and attorney for property, and I help to navigate the complex world of estates. I either hold the executor's hand through the process, or I take over for them. So as I alluded to before, I was going to give you a little bit of my background. So as you know, as you mentioned, I'm a CPA of the CA legacy. I also have my CPA from the state of Illinois, and then I've also did my Certified Executor Advisor, and just finishing up one of the STEP programs, the CETA, the Certificate of Estate and Trust Administration. I have one exam left. And so my focus on the estate world started about 10 years ago when my dad had passed. And my dad's wife at the time was totally emotionally compromised. And my brother was the other executor on the estate, and he goes, "You're the accountant, you do it." And I go, "Oh, sure, no problem, I'll do it. Well, you know, it's numbers, I'm pretty good at those, I should be okay with that." And wow, I was surprised at how much work was involved. He had, like I said, he was a dual citizen, so he was living in Florida at the time, and he had property up here, and to deal with all of the different complex matters, and he tried to set up one of those, template trusts, and so it didn't, couldn't get through that. And then we were trying to get information from, the trust companies wouldn't help me, and the estate lawyers are a little on the expensive side. So I go, what other help do people have out there? And so I completed the work, and I thought to myself, how many other people need this help? So I happened to approach one of my friends who was a tax partner at one of the larger firms, and I said, "Is this something that people need?" He says, "I've got 400 partners that need your name," because as a partner in a CA firm, they couldn't be the executor of the estate, and if they gave if they did tell the client to go to the trust company, they would lose the business to the trust company. So they were going. He says, "No, it's a great." So I pursued it more, and I started my journey about trying to learn everything about estates. And I'm still learning today, so there's lots to learn. So on my journey, I started jotting down all the things that people needed to know right now, not further on or when they had passed, but things that they should know now about estates and the estate law. And so I started putting it together, and I created this program called "Are You Leaving a Legacy or Landmine?" I want to present you today some of the items in it, and make sure that you and your clients are aware of them. So there's four areas, that we shall discuss: law, tax, executor issues, and then I'll see if I can show you how we can work together. So in terms of the law, these are the areas we're going to cover, about 10 of them, and the first one, as you all know, there are 3 mandatory documents, or documents that you should be in place when you prepare for your estate. So you want the will, you want a power of attorney for property, and a power of attorney for personal care. And despite the importance of all of these documents, I'm not going to go into much detail on them because I'm assuming you all know them based on knowledge in the room. But of these, the will, Stats Canada has showed that 62% of people don't have a will in Canada. And then there's another 12% of people that do not have an up-to-date current will. So that's a total of 74% of people that need help in this area. So we say, well, why do people not have wills, right? And so there's a lot of different reasons that were stated. Some were that the estate is not big enough, they don't have sufficient assets to warrant, putting a will together. Some say they don't want to start a fight in the family. If I appoint John, then Bob is going to get upset, so let's just avoid the whole family conflict. Some say, well, nothing bad will ever happen to me. They have what I call the Superman syndrome, that they're just, I don't want to worry about that. It's all good. Oh, sorry. Needed to turn the page, not the slide. Some believe that they say, fortunately, I don't need a will yet. So, right? Some have that superstitious, don't want to jinx themselves. Some are just too busy, and I think that's the majority of people. I'll do it later, because stats can also show that it's the people with the most wealth that do not have the wills. Which, so I would think that's not money-wise, that's the criteria, it's just time-wise, right? So they also wait for a perfect time to do it. It's like, oh, well, I'll do it later, I'll do it later, I'll do it later. Thinking that, oh, when I get married or something, some important life event happens, but not knowing that we can just update the will as we go, and it's more important to have one right now. Some people do believe it is too costly to have a will, and some people inadvertently do it, and I'll talk about, so marriage actually nullifies the will. So people think that they're getting married, it's okay, I've got my will, he's got his will, in my case it's his guy, and we get married and we our families are looked after, but the actual marriage contract will nullify the will, so they are actually intestate at that point in time. So, implications of dying without a will. I think that one of the reasons that people don't get a will is they don't realize what are the implications of passing without a will. So I'm going to, I'll put them up there, but Sullivan Law has said that there's these 10 things. I'll just read them to you so I can put my own words, but so the law decides how the estate is distributed among your spouse. So it's already predestined by law. If you do that. Common law, spouses are not looked after. It will cost the estate additional time and money to get a personal representative appointed, because someone has to apply to the courts. You don't have an executor that's in place at the point in time. Dependents are not provided for. Guardians of your children are not established, and just as a note, even if you do put, sorry, Ed?
Just one, while you can finish it, I just one quick question.
Okay. Dependents, the guardians of your children are not established. And just a quick note that the government always has to vet whatever guardians you put in their place, so they could overrule who you do have in your will anyway. There's possible increased tax and probate costs. You can't get into the estate planning and plan around that using wills. And the courts may require a bond to be posted if there's no will and someone applies that. And I'm sorry, your question?
You said marriage nullifies the will.
Yes.
Is that on the basis that the will predates the marriage?
If the will is before the marriage and there's nothing in the will that says this is done in advance of the marriage that I'm about to have, then the marriage contract will cancel the will.
Okay, so if the will is subsequent to the marriage, it would be enforced, right?
Yes, it would be.
So it's only if there's a marriage. It's only if it predates the marriage.
Or divorce.
Yes.
Right. Okay.
Or divorce.
Or divorce. Okay. Good to know.
You can add a line on that slide, the Barry, it's 2 years before the will gets.
I'm sorry?
It takes forever.
Oh yes, it depends on which courts. Yeah.
Some old guys are about ready to retire, and they could make a decision on a postage stamp whether they can spend any money, so they set forever. So real estate, everything, just stock portfolio, can't touch the damn thing. Takes forever. Years.
Mm-hmm. Right.
It's horrible.
So, common law spouses are another problem when you don't have a will. Because common law, as you know, in the tax world, after a number of years, the government says, well, you guys are together, and for tax reasons you're put together. But for common law purposes, you're not. So if you think that you're living common law and that your spouse is looked after, they are not. And so is the government will take over they have a preset formula as to who gets what, children, parents, and so on. And none of it allows for your common law. So not only that, but like the accounts are frozen, and they have nothing to work with. So it's very important to have contracts and estate plans so you don't get blindsided.
Michele, with respect to matrimonial home, that is still divided.
My understanding is it has to be 20 years of because if you have it
20 years?
Yeah,
I thought
before
it was
it's considered. No, not for the law. But I mean, I can check for you if you'd like.
I'm just asking.
Yeah, no, it's not. If the house is in your name, it doesn't become a matrimonial home for a while. I think it's 20 years. So, so let's talk about probate. I'm not sure if all of you are aware of what probate is. I'm going to just back up for some of us in the room that don't know. Probate is a document where the government ratifies that this is the last will and testament of a person. So what happens is, if I were to be the executor on an estate, and I take this document and my name is in it, and I bring it to the bank, and I say, I'm the executor here. Please give me this person's assets, and they give it to me. And then someone comes over with a more current dated will and goes to the bank saying, well, you shouldn't have given it to Michele, I'm the more current executor. Then the bank has no recourse other than to come back and say, Michele, if you don't mind, can I have the money back, please? And so as an alternative method, what they've done is they ratify it. You send it to the government, you send in your amount of 1.5% approximately of the estate, and they say, yes, we'll use this will as your final will and testament. And so, Mr. Bank, you can use this and work with it. Michele has the authority to be the executor on that. So, and as you might know, lately there's been a lot in the news about death tax. Death tax is still really the probate. All they've done now, though, is I think in 2016 they added an estate information return. So before, it used to be run by the Attorney General, and the lawyers would guess at, it's about this much for the estate, let's say $1 million, right? And now what they're doing is within 90 days of you applying for probate, so if you don't need probate, you're okay, but if you have to apply for probate, the date of the probate application, you have 90 days to file what they call an estate information return. And what that does is it basically, the probate document just has a lump sum, $1 million in it. The estate information return has a detailed breakdown. This is the bank account, this is, the investments that are in here, this is all the different assets that are in there totaling the $1 million, and you have to justify each one of the numbers. And now what they've also added is, I'm not sure, I guess the number of you in your room might know, the Ontario government no longer has the provincial corporate taxes. So they're now using those auditors to audit probate. So they have 4 years to audit probate, and the onus is on the individual taxpayer to prove that it's right rather than the ministry to prove that you're wrong. So there's a lot in there for executors to know, to make sure that the numbers are correct and that they have proper backup for the numbers, because they could get audited within 4 years' time. And if you think about it, the executor year is really as a year that people want their money ahead of time, but the government has 4 years to come back. And then if you add in the new charitable the donation rules that say you have 3 years, and they changed all the rules with the taxes on death. I mean, you have to do everything within 3 years to allow for it, but they still have 4 years to do the audit. So the right hand is really not talking to the left hand, but it's not really different with the world as we know it with government, right? So,
Michele, isn't there a significantly higher onus put on the executors around the valuation report?
only that they have to prove it right now, as opposed to the government proving that they're wrong. So they need to.
And if there was a distribution made based on the wrong numbers, could there be legal liability?
Yes,
Financial
the executor needs to hold back and not have, make sure that they retain that money. If they have distributed to the beneficiaries and all of a sudden the government comes back and says, no, you owe us another $100,000, and they don't have that left in the bank, they will either have to go back to the beneficiaries, get the money back, which they probably will not do, otherwise they will have to fork it themselves.
But I think Paul's also asking, is there an onus on the executor if the estate information return is basically stated incorrectly?
Well, it's not that, but it's what Michele went to, and that is if ultimately there's money that can't be recouped.
But this also must be correct. If it's stated incorrectly, that can be against the executor.
Yeah, if you find out afterwards that there's something in the estate information that's incorrect, you've got, I think, 30 or 60 days to refile, and there is quite there's some penalties involved as well.
Penalties.
If it's not filed correctly.
Michele?
Yeah.
From CRA, you can get a clearance certificate. Can you get the same from the probate?
They don't offer a probate certificate. Yeah, sorry, thank you for that, because I was going to also mention that there is no clearance certificate, so you cannot get something to say that the government they will not open it up.
Just so you guys know, in Alberta, our probate is capped at $500.
There you go. I know that they are putting a directory in place or a pool where you know in Quebec they don't have a probate tax because they have a directory of all the wills and everything's filed there. I know that I've heard that that's in the works in Ontario, but I don't know how long it'll take to get it in place. All right, what's next? What happens when an executor declines the position or has passed? A lot of people are, you get concerned saying, well, do I really want to be the executor? Do I, that type of thing. You're always allowed to decline the executor position, even if you are the last on the list. You do not have to take on that role. But the problem becomes if you cannot intermeddle. You cannot start the process and then say, oh, I don't want to do this anymore, and then back up. Because if your name is on that, you have to follow through with it. Otherwise, you are still liable for anything that doesn't happen in that estate. So if you want to step down for whatever reason you might have, you actually have to apply to the courts and get removed off as executor. You can't just stop what you're doing. So be really careful about that intermeddling. Like you're starting off going, okay, I'll start the process, help out, help out, help out. But that it could be conceived as you being the executor. And if that's the case, then you are fully liable for whatever goes wrong or might go wrong with the estate. So,
Are you able to start, and then if you recognise that it's a bigger endeavour than what you first thought, can you appoint an agent to assist you at that point?
you can always appoint an agent to assist you. You will still always have the final decision. So if you are the executor, so whatever does happen, you are ultimately liable for. An agent will not be taking over the liability for you of what's happening, but they can do all the legwork for you. Any more questions? So, FLA, Family Law Act, and the Succession Law Reform Act. What I wanted to say with this is that they overrule sometimes what the will has to say. So you cannot, in your will, determine that I'm not going to give anything to my wife. Because the Family Law Act will kick into place and say, well, by law, even if you divorced her, she's entitled to 50% of whatever. So they will kick into place and say, no, we will protect them, and your dependents as well. And the Succession Law Reform Act also will overrule. So let's say if you do in your will, or I've seen situations where you can bypass your will by putting designated beneficiaries for your RSPs or for your insurance products and all of that stuff, and nothing goes back into the will. And there's taxes to be paid in the will. CRA has the right to go back to those people that you've sent the designated beneficiaries and say, sorry, that money belongs to me. So you have to be really careful, even though you might think that you have the money tax-free, you're the designated beneficiary. You have to wait, and the government has a right to that money. Joint bank accounts, this seems to be all the rage right now, and so I wanted to talk a little bit. This is the legal part of it, and then we'll get into a little bit more of the accounting part of it. What happens on the legal part is there is a transfer of ownership, right? So from points of view that you have this joint bank account with someone, if whoever is connected with me, if I have a joint bank account with you, they have access to that money. So my creditors or my spouse or whatever could have legal access to this joint bank account. You may not think that's the case. I'm signing on with my mom so that it make it easier for, should she transition, but that money is not safe if there's anything that's going on with me. So people need to understand the legal implications behind what could happen if you do that. Even though my intention might be that it's mom's money, it's not mine, that there might be a resulting trust or resulting gift. We need to know what's going on with it. Is the intention for mom to keep the money for her, or is it to eventually give the money to me? We need to know all these things. And it does affect probate, because in part of the probate, when they send you the information, they will say, is there any joint bank accounts? And because they want to know, they know that everyone's trying to bypass probate through these joint bank accounts. If the account is in fact mom's by intention, then they expect it to be on the probate application, and that will be part of the audit that they're going to have to go through. And then we talk about creditor issues, that it's not protecting the creditors, actually imposing more on the creditors. So, non-Ontario US property. So when you do an Ontario will, you are actually looking at, your will is covering your assets in Ontario. So anything outside of Ontario is, it's not covering. So you would want to have, if you've got a property in Florida, for example, you would need a power of attorney document in Florida and a will in Florida, because the officials down there will not necessarily, they won't talk to you. And so you can have all the documents in place and say, yes, that's fine, you can get probate up here saying I've got authority, but if the people down there won't help you or won't talk to you, that's not going to help you in your situation. So you need to be aware that just because you have a jurisdiction, everything's valid up here, anything outside of Ontario, more specifically US, it's a problem. When I was at the STEP conference in June, there was they talked endlessly. This guy, an attorney from Florida got up and said, hey, we aren't going to talk to you. So you need to do all these things and make sure that you have that. Because people think, oh, I've got a condo in Florida, not think more about it, but it does affect what happens should you pass. So also, non-Ontario executors or powers of attorney. So same principle happens if you've got a foreign executor. They would have to apply for probate. The Ontario government may or may not accept them. They usually would have to file a bond. The bond could be $15,000 for every million, is what I understand, to protect the money should you want to take it out of the country. It also, as you may or not know, if a U.S. executor will cause the estate to be a U.S. Foreign estate. So you don't want, you have to really consider what the implications are before you accept someone that's going to be a non-Ontario person. Also the last one, investment managers cannot take instructions from a U.S. POA or executor. I'll often get asked to step in as an intermediary because they can take instructions from me, but they cannot take instructions from a U.S. person.
So if you have a share portfolio for a client in the US, in the custodian there, they need to have a US will.
That's my understanding, yes. And it's more complicated because it depends on where that institution is residing. So it's really a lot more applicable for real estate, but there you go. So that is the end of the legal area that I'm going to touch on today. I usually do this presentation with with an estate lawyer. Her name is Maureen. So she gets into all of the details of the legal stuff. Yeah.
Can I ask one question on the previous slide?
Yeah.
The U.S. executor will result in a foreign estate. So is that for purposes of Ontario? That if you have a U.S. executor, that's considered for Ontario a foreign estate? Is that what you mean?
That's my understanding, yes.
The US will start looking for 1041 on the estate.
Sid, we've experienced that with others, where Paul especially, one of the clients had their son as an executor, and the son lived in South Africa,
Right.
and if the estate had gone through, it would have been under South African rules.
Well, it's basically mind of management, just like
Yeah.
the corporate residency rules now.
But that's for Ontario. So if you have an Ontario resident individual with foreign property in the U.S., Florida, let's say,
Mm-hmm.
and if they have a U.S. executor,
Mm-hmm. For sure, it's Ontario. I'm not sure about the other provinces.
What I understand, the majority of trustees or executors determines the residency of the state.
It does,
So,
yes, and also
For taxes.
for taxes, and also, if I was to come on as an agent, it will flip because I'm going to be looking after the mind and manner, as you pointed out. I will sway it to be more of a Canadian estate. So, one of the ones I worked on, the executor was in the UK, the sister was in BC, the executor in the UK was the only executor, so we brought on myself and the BC sister so that we could move it into being a Canadian estate.
so that point is Canadian controlled. Yeah, okay. But for the U.S. purposes, you need a U.S. executor, you're saying?
Yes, I cannot act as, if you are going back to the US, I cannot be your executor in the US. I can look after your Canadian property, but I cannot look after your US.
All right, got it.
So taxes, I'm only going to touch on it a little bit. I think a lot of people in the room here are tax professionals, and I mean, I know enough to be dangerous for taxes. So I just want to bring up some points that are generally discussed. One is, we talked about joint property and the joint bank accounts. As you all know, that when we transfer, there's also a legal implication. There's also a tax implication, or can be a tax implication for these joint accounts, and people don't keep that into consideration. You know, they transfer over the cottage, and they already have a principal residency, and all of a sudden, boom, you got a capital gain, or, you know, they're trying to bypass these rules without really knowing the rules, and they're not seeking out your help either. They're trying to keep all their professional fees down. So, you know, just to be aware that people out there are doing this, and that they shouldn't be, right? Gifting of assets, we all know so very similarly. I mean, there's rules on gifting, there's you know, attribution rules, there's a whole bunch of different rules that people need to be aware of before they just go ahead and transfer and gift something to their children. And tax planning. Tax planning, as you know, is so important, and there's also a huge estate side of it as well, because we talk about, you know, if you know, these probate taxes. So there's ways of, even though it's only the 1.5%, there's ways, I mean, you want to save every penny you can, and there's ways of avoiding this probate, such as we talked about the RSPs. You have, the RSPs fall outside of the estate, you have a designated beneficiary. Some insurance programs are the same. If you have, a great one would be if you have your own business, like a business owner. If the business owner does not have a second will, you can bypass the probate rules with a second will. If you have just the current will, your business would have to get value. So everyone knows the cost of a valuation of a business, $5,000 to $7,000, plus the time it takes to do that. That would have to go into your probate document, and you'd pay taxes on that business, whatever value it ends up happening. Versus if you create a second will, the second will that just says to have specific non-probatable assets in it, because probate is only used for a third-party ratification, right? So we already know who's going to get the business. So we create a second will, and then this will does not need to be probated. So it saves the valuation costs, it saves, you know, time and money and effort. So there's a lot of different ways, but we want to make sure that we are doing the tax planning. So that's why we want to make sure that the clients understand what the importance is of you know, having your professionals in place, right? So my favorite part, the executor issues. So let me give you some examples of things that I've just run into that will show you the importance of, you know, how the estate works and what we just talked about for the tax and the legal stuff and what we're about to get into here. I had one client who, trying to bypass probate, they left the cottage, the family cottage, in the estate, and then she put all of the property outside of the estate, so her lifetime RSPs, all of that stuff, and it was a family cottage. She wants to leave this family cottage to her kids. And what ends up happening is there's no money left in the estate to pay I think it was $400,000 capital gain on it, because she already had a principal residence as well. And so now what happens, right? So in this case, the four beneficiaries happened to get back together and said, okay, well, we'll put the money back into the estate to pay it, to keep the cottage going and all that stuff, and they created a fund. But if any of those beneficiaries chose not to do that, there's no recourse. They didn't have to do that. And you can imagine what the family dynamics would be just because she was trying to bypass probate. And in this particular case, one of those four beneficiaries was disabled. So she was trying to set up a Henson trust for them, and she put it through an RRSP, but didn't set up a trust deed. So in this case, there was nothing to support the actual Henson trust. So we kind of went, well, we could, but we couldn't. And it ended up being that it was easier to not push the fact that there's a Henson trust, but now her ODSP benefits were affected by it, right? So all these things that people are not considering when they look in isolation, as opposed to looking at the whole picture of what they're doing. And then I'm just finished an estate. We talked about the foreign executor. This particular person also, the will wasn't properly executed, so now you have to go through the hoops to make sure that the government will accept it. they had an incorporated business. The directors, the executors automatically become directors of the incorporated business, so that adds added to it. The voluntary disclosure in there, so you can just imagine all the different things that add up and add up and add up, and then the beneficiaries go, "Where's my money?" And you go, "Well, we're trying to deal with these issues and these issues and these issues and these issues, trying to protect them," but they just get upset saying, "Well, the money isn't coming fast enough," and all of that stuff. So just giving you some ideas of what you run into, I mean, in that world, or some of the situations that you can run into. So what is the risk that an executor has? So the executor takes on full responsibility as if they own those assets and becomes personally liable for everything. So in these cases, if we hadn't gone back and looked at, if the tax returns were filed correctly, or if we hadn't done, we sold the house for something that was far less than fair market value, the benefit, and there's any recourse on it, it's the executor that gets personally liable. They either have to repay any compensation that they may have taken, or they have to take it out of their own pockets. So it becomes very much of an onus on the executors to make sure that the estate is done properly. Yeah?
But one of the things as an executor, you would take on some insurance so that would never happen.
I have mentioned insurance a bit later on, yeah, that there is a protection that we can get, yes, for sure. So I'll make sure I'll touch on that in a minute. So when do executor duties begin? We talked about probate, and we talked about, a lot of people think, well, that means that when probate happens, that's when I take on my responsibilities. Now that is true only if there's no will, because you have to go to the courts and apply as a representative, and then you get authority to look after the estate. But if there is a will and it does name you, your authority starts immediately. That means you're looking after funeral costs, you're looking after anything related to the estate. So just want to make sure that you understand that probate does not give you the authority to start looking after the will. It's the will itself that does give you the authority to do that. The probate just ratifies saying that you are the executor. If you don't want to be an executor, we talked a little bit about that. You can renounce right at the beginning. You say, "I do not want to be the executor, I renounce," and then there's no implications for you, even if there's no one that follows you. But don't start, because you could get caught with intermeddling, and then the responsibility is yours. You'd have to apply to the courts and say, "I no longer want to do it for such," and you actually have to have valid reasons for not wanting to be the executor. Also, the courts can force you to do it. Can I get assistance? Gee, I'm glad you asked that question. Certainly. The executor job is to make sure that the estate gets liquidated, not to necessarily do all the work themselves. And as a matter of fact, it could be against what the executor, that they need to do the best for the estate. And if they are not an investment advisor, for example, or a tax preparer themselves, if they don't seek legal advice, that could come back to haunt them. They could be liable for not having the estate done properly. So they do want to seek professional advice. So I mentioned estate lawyer, tax preparer, and of course, as an agent, I can help them make sure that I coach them through the whole process, doing as much or as little as they want. Bankrupt estate often comes up. What happens if it's a bankrupt estate? We talked about them being personally liable, right? So what happens if the estate is bankrupt? Basically, if there's a fear that the estate might be bankrupt, you stop immediately. Because if you start commingling, you're going to get involved, and you want to make sure that you hire a bankruptcy lawyer right away. Because you don't want to, you want to know what the risks are. And also, if you go through and if there's not enough money, let's say even to buy a tombstone for the person's grave, if there wasn't enough money and you do an elaborate funeral, the executor can be personally liable for it. So you want to step back and say, what is available in the estate before you start doing that work. Executor compensation. So as a general rule of thumb, as you know, in Ontario it's common law, so there's no really specific rules that have been set out for it. But under common law, the general rule is 5% of the value of the estate. So they call it 2.5% of the value going in and 2.5% of the value going out. And that allows for any gains on the sale of investments or stuff. Because it's like it could be that you're going into there at one point, and then the house actually sells for a couple $100,000 more. You are actually entitled to the compensation on the higher sale of the asset. But there's special rules in the Succession Law Reform Act that talks about if you're a professional, you cannot get double dip basically, and you might have a conflict of interest. So it's highly recommended that even if you are an investment advisor, that you do not do the investments on an estate that you are working on or you're the executor for, because they have really strong rules on that. I put pre-taking in there. If an executor cannot be paid up front, they would be paid at the time that the estate is liquidated, unless they have a term in the will called pre-taking that allows the executor to take the money as they go. If it is not in the will, it's called pre-taking. You cannot get compensated ahead of time. And it will cost the estate the same to hire a professional executor as it will to hire a family member. 5% is 5%. It doesn't matter whether it's the executor or if it's a professional or if it's your cousin Bob that's doing it.
Michele, is that 5% per executor or total?
Total. So the trust companies, they can go on a little. They'll contract out of the 5%. But the 5%, if there's 3 co-executors with 3 siblings, they would have to split the 5% between them. So, solution. We're hoping to you saw earlier that in terms of, we can help you on the wealth advisory with the wealth stewards. And also, we can fill in the other half, the estate side as well. We do provide initial evaluation and assessment when we get set up as an executor on people's power of attorney or wills. We'll take a look at it, make sure that a lot of these pitfalls that we just looked at, these landmines, that they do not, that they're addressed, and that the client is not going to get involved in that. So making sure that there is peace of mind in that area. And then we want to form your team. We want to be part of your estate team. And I mentioned that on our team is also an estate lawyer, Maureen. She is also a family law. She practices family law, and she has her master's in tax. So she's got the full gamut. And so when we put the wills together, we're looking at not only the tax planning that you may have done, but also making sure that it all fits together, so that they have the proper team behind them should anything happen, or have any questions, or need anything to be addressed. Like, can we bypass probate by putting the yacht in a second will? Things like that you don't always have the answer for right away, but enough people if you have your whole estate team in the room when you're actually doing this will, it makes a significant difference to the client. They feel as if they're completely done. This program of Are You Leaving a Legacy or Landmine has been set up as a kind of a lunch and learn for your clients. So I would give you the tax piece if that's what your profession is, what the tax numbers that we said, and there's a lot more actually involved. I only mentioned 2 or 3 of them, but things that you want your clients to be aware of, so that there's no discongruity between you and your clients. You are the tax professional. Maureen would be there doing all the estate law. I would do the executor stuff, and together we'd form the team for your clients. They get all the information, and then we can make sure that their wills are properly done and executed. So on that note, we have, I put chaos for for bad wills and order for good wills. But we've set up a will movement where we're trying to just get 100 people to say that we've done they've done their wills. So on our website, there's actually a place where you can sign up, and I'm trying to knock out that 74% down, because it really, there's so many people, there's so many opportunities. There's a great way to talk to your clients about, you got everything looked after, because as we said, they could say they have a will, but it could be null and void, and we don't even know that. So it's an opportunity for us to go in, help you, and see if your clients are properly looked after, foot in the door, value added, and if they do have a will, have them sign up on our page, and if not, we can certainly help them through the whole process.
Just before Peggy says something, to me, one of the important things here is there are many doors to entry to a person's wealth situation, to engage, to provide value. And to me, one of the areas that is least attended to, in my opinion, is the estate area. Okay? You could have a seminar on about investments. Lots of people have heard that story, but a lot more will show up to listen to a message about estate. It's confusing. Are you guys confused after all that stuff?
I hope I didn't talk too quickly.
No, I think Paul's right, and one of the things we've even found, Michele and I, when you're out talking to people, you know, they really do not have a will. And even from the perspective of an accountant, how many times do you get a call from the lawyer saying, I need this, 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 and this, and this, and you provide it all, and like the lawyer's getting paid like $500 an hour for the time, and you've provided all the work for the will. I mean, I'm sure everybody in this room has been the guinea pig for the lawyer. And we're saying, in fact, it's not the lawyer that really needs to be the executor, it needs to be the people in this room. And you talk to the lawyer for some of the final details. And I think Michele has clearly shown you that it's actually so convoluted right now, the whole estate area, that it's actually so important to have either a person like Michele on your team, that you can say to your client, look, you don't have to look after that anymore, we've got the right person. And that actually closes our whole loop of the services that we can provide to the client. And if even after all of Michele said, if you wanted to know what's involved on, you know, listing all the assets for the return, the initial return, we've got some of those documents. So just talk to Michele or I, and we'll make sure that you get a listing of some of those things that are necessary.
And then on Rick's will amendment, will that white box that said will planning will be blue.
I know we always ask the client, do you have a will, and they'll say, yes, I have a will. Do we not offer a service where we can say, can you provide us your will, let us read it for you, and give you a critique of whether we think it's a good will or a bad will? Do we offer that?
We're just about, that's exactly what we're going to be doing for our Well Stewards clients. Is
That's the initial assessment
an evaluation.
It's just on different issues.
Yeah.
Mhm.
Yeah.
We're going to look
It
at
may not even be current, because how many people do we know? Paul, you'd be an example. You know, you divorce somebody, and the will has your ex-wife as, you know, the person who's Paul. Actually, that has happened to Paul's sister, so we have actually incurred that problem. But these are the things that happen in an estate, and you know, every time you look at one, you can take the time away from that client, and we've got something that can help them. So
I'll give each one of you a call and see if we can set up something where we can to show you how we can be of value. And there's a referral system as well in place on the estate side as well. So we can talk about that and see if that would fit for you and your clients. That would be great.
thanks, Michele.
Thank you, Michele.
Perfect.
Thank you.
So our next speaker, one of the other things that I know that happens within the accounting firms is your clients are at that point in their career that they're ready to sell their business, and there's a succession plan that's needed. And some of you may have help, but others don't know what to do with that client. What can I do to help them? And the benefit is Stephen Cummings is one of those people that can help